I think it is clear to believe in the power of ideas.
Fresh thinking to the Manhattan Institute.
My name is Isaac Gordetsky. I'm the project manager for Manhattan Institute's Center for Legal Policy from New York City. And actually really happy. I was watching when the Boston Bruins beat the Penguins and then the Hawks beat the Kings, and I was watching that schedule because I knew that if we had to compete with the local team going for the Stanley Cup, we were not gonna make it. So I'm glad to see that we have a great turnout tonight with the help of a lot of our co-sponsors, who I'm going to thank individually in just a minute. But I want to quickly just kind of outline what it is that we're going to be exploring here. The title of our event is Overcriminalizing the Land of Lincoln, ? We're going to be exploring whether or not the trend of overcriminalization, which has really taken hold on the federal level and in several states, whether that's a factor in Illinois and to what degree, and how it can be solved if it is. And so a lot of different groups who work on this issue, which is interesting. I guess I should mention there's a monthly meeting held by the Heritage Foundation that brings a wide array of groups together at the table, and you'll look around the table and you'll see the ACLU, Families Against Mandatory Minimums, Heritage, Cato, the Federalist Society, National Association of Criminal Defense Lawyers. These are people who do not agree on much, but they agree that overcriminalization is a problem, and it's something that we should be looking at. And so that's what we're doing here on the state level. And we define at the Manhattan Institute on a basic level that other folks can add to, and I'm sure they will when they're up here on the panel. And that's looking at the traditional scope of the criminal law. It was at first very basic. It was to punish morally blameworthy and egregious behavior that the public agreed was morally blameworthy and egregious, and there was no question as to that point, and nobody could say that they lacked the notice that such behavior was criminal. And it was to protect the public, and it was pretty fine-tuned. In the last few decades, especially in the last couple of decades, we've seen a great expansion in the scope of the criminal law beyond that purpose. And first, it starts with just the codes themselves on the federal level and on state levels. The expansion of the codes, which create a lot of problems, duplicative laws, laws that are very broad and vague, laws that don't have culpable mental states required to prove the elements. Then you have a growing regulatory state. So on the federal level, there are over 300,000 criminal penalties in the regulatory code, and nobody can count all of them. In fact, it's funny, I was at a hearing on Friday on the Hill. It was a task force that was assembled by the House Judiciary to combat overcriminalization, and Congressman Sensenbrenner from Wisconsin said that when they started this task force, he asked some of his staffers to approach the Congressional Research Service and asked them to have a full and definitive accounting of how many criminal laws we have in the code and in the regulatory system, and we want this, as soon as possible. And CRS responded pretty frankly, we don't have the time, nor the manpower, nor the resources to even start doing something like this. I think that gives everyone an idea of what we're actually looking at here as a trend. If we can't account for the criminal laws in this country that strip away individual liberty from someone, that can confine someone in prison, that is a real problem. So why is the Manhattan Institute a New York City think tank here in Chicago, Illinois? and why were we in Columbus, Ohio 2 weeks ago. This is part of our initiative to kind of supplement what the great groups are doing on the Hill and on the federal level, and to bring this important issue on the forefront on the state level. We think that the same problem is very prevalent in the state legislatures, and we want to make sure that people are paying attention and to see what we can do in terms of solutions. We have great experts that will feature later today on the ground who are working on these issues and have great insights on the type of problems we have in this space. And I think that we shouldn't stop at the federal level, and we should try to branch out and focus all our efforts to really stop this problem. And so what I want to first do is I have a few thank yous that I hope you can sit here through, because this event would not be possible without so many groups that are kind of represented in this very attractive poster up there. But it really doesn't do justice to how instrumental a lot of folks were here to making this possible. So first I want to give a special thank you to the Illinois Association of Criminal Defense Lawyers, notably its Executive Director, Angela Ramage-Wolf, whose help and effort has been invaluable to me, and we've spent quite some time on the phone, and she's been great with the support and advice, and I couldn't have put on this forum without her, and so thank you very much for that. I also like to thank the Liberty Justice Center of the Illinois Public Policy Institute, especially the Executive Vice President of IPI, Christina Rasmussen, and Jacob Hubert and Dan Cohen of the Liberty Justice Center. At the Federal Society, I'd like to thank Lisa Zell, the Vice President, Director of the Lawyers Chapters, Jonathan Bunch, who's the VP and Director of State Courts, Peter Bisbee, Director of Membership, and Chris Hage, who's our panelist here for helping us get a lot of the members here today. And of course, the Heritage Foundation, Paul Larkin, who's moderating our panel later today. He's a senior fellow at the Heritage Foundation, and John Malcolm, senior fellow and policy director. The Texas Public Policy Foundation, Jeanette Moll, Brendan Steinhauser, who's the director of communications, the whole communications team there, Mark Levin, who's the director of the Center for Effective Justice, and also the America's Future Foundation chapter in Chicago is not an official sponsor, but has been very instrumental in outreach, and they have a lot of great events that I urge you to check out and meet some of their members here. And also, I have to thank my own colleagues. James Copeland, who's the director of the Center for Legal Policy at the Manhattan Institute, is really a leader in this space, and he's got some great scholarship out there on this on this subject, and introduced me to this topic. So I owe a great deal to him. And our events team, Taisha Camacho, who's here today, she'll be running around with the microphone and really put this whole thing together logistically, has been a great help with Debbie Ezard, who is also on the back end of this on the event side, and Michael Allegretti, who is our VP of Programs and our Director for the Center for State and Local Leadership, as well as Kasha Zabawu, who's the Deputy Director. And they're really kind of pioneering Manhattan Institute's role on the state and local level in terms of various policy initiatives like pension reform, policing, and so on and so forth. So thank you for putting up with that. And now I'm going to go ahead and introduce our keynote speaker, Judge Joseph E. Birkett. His bio could be found in the packets. I'm not going to read through all of it. I'm just going to highlight some of the notable items, and there are a lot to choose from. Judge Birkett is a judge on the 2nd District Appellate Court in Illinois. After graduating the John Marshall Law School as reigning moot court champion, he was the Assistant State's Attorney from 1981 to 1996, trying more than 100 felony cases to verdict and serving as Chief of the Criminal Division from 1991 to 1996. In 96, in October, he was appointed to DuPage County State Attorney. He was elected in November as State's Attorney for the first of 4 terms. And during his career as State Attorney, Birkett was elected President of the Illinois State Attorneys Association and Chairman of the Board of Governors of the Office of the State Attorney's Appellate Prosecutor. He served on the Governor's Commission to rewrite the Criminal Code, the Illinois Sentencing Policy Advisory Council, Criminal Law Edit, Alignment, and Reform Commission, and the Interstate Gun Trafficking Task Force. Birkett is the author of more than 100 laws that were enacted by the Illinois General Assembly. He's also the author of numerous publications and has been a frequent speaker at national forums. On November 3rd, 2010, the Illinois Supreme Court unanimously appointed him to the 2nd District Appellate Court, and he took the oath of office on December 13th, 2010. I'd like to now welcome Judge Birkett to give his remarks on our topic. Thank you so much for being here.
I was told that I have 20 minutes, so I'm going to leave Chris Hage the responsibility to make sure you're getting you off this or away from this podium in 20 minutes. I'm delighted to be here, Isaac. Thank you for that wonderful introduction and for for talking me into doing this as well. It's so nice to be here with so many people who have supported me when I was running for office, as well as people who I had the pleasure of working with. Steve Baker is here, former public defender, now at the Cook County State's Attorney's Office, or the Cook County Public Defender's Office. Sorry, Steve. Legislative Liaison, who I've had a great relationship with over the years. Some of my former colleagues, Rick Feenstra, who's in charge of community prosecutions for the DuPage County State's Attorney's Office, of course, Chris Hage, Phil Collins, former assistant, and I'm also delighted to be with Justice Holdridge, who I've long admired, Bill, for all of your work, for showing up in snowstorms to my events when I was running for office. Thank you so much. You know, when I began my career in 1981, I know the topic is overcriminalization, but really Illinois was suffering from undercriminalization. We had penalties that were extremely lenient for some very serious offenses. Indecent liberties with a child, which is now predatory criminal sexual assault, was a probationable offense. Persons convicted of DUI, driving under the influence of alcohol, could get supervision after supervision after supervision with no mark on their record. The list goes on and on. So I was part of that era back beginning in the early 1980s, 1981, where the pendulum started to swing back and we started to get more aggressive in terms of public policy, in terms of punishments, taking more discretion away from judges. In the 1970s, there was a push to go to determinate sentencing. In 1978, the Illinois General Assembly changed the law, went to determinate sentencing as opposed to indeterminate sentencing for offenders convicted of serious offenses and sentenced to the penitentiary. The public was frustrated, upset with the way the criminal justice system was treating serious offenses, from murder to burglary to rape to robbery, etc. In the background, there was also a push in Congress to criminalize and punish more and more offenses. I'm not going to talk about what's going on at the federal level, other than to give you some summaries, but I would recommend you know, many publications from the Heritage Foundation I had a chance to read through in preparation for tonight's presentation. An article, Overcriminalization in Social and Economic Conduct, by Paul Rosenwig from 2003. Nothing much has changed in the last 10 years. It's pretty much just overcriminalization on steroids in terms of the federal level. But that being said, one of the common denominators, both at the federal level, state level, county level, and local level, is the power of the prosecutor to make the decision on a policy level, what charges he or she is going to bring, what you're going to pursue in terms of what your strategy is to protect your community, to root out crime and protect the public. Justice Jackson said that second only to the power to declare war, the power of the indictment is the most powerful tool in government, because prosecutors literally have the ability to take a person's liberty away. And when an indictment is brought, you know, the stigma of an indictment, even if a person's acquitted, can ruin a career, ruin a reputation. When I first began my career as a prosecutor in the state's attorney's office, you know, I watched what was going on under my first boss, Mike Fitzsimmons, who was a wonderful man, former U.S. attorney, a former assistant state's attorney in DuPage County. But the office had no policies. Laura, you know what I'm talking about with regard to policies and practices. If you don't have policies, if you don't have a mission statement, the ship is, you know, afloat at sea without any real direction. So you had sentencing decisions that were being made by prosecutors in the courtroom without any structure, We used to have to do what was called what we called it a pros memo. In a prosecution memo, we outlined the general facts, and we recommended what the sentence was going to be. I had no experience. I came out of law school. I wanted to be a prosecutor, but I had no experience measuring what should the punishment be in this particular case as opposed to some other case of like character. And you talk to your colleagues, and there was no structure. That's something that all changed when our former Attorney General for the state of Illinois and my really one of my favorite bosses of all time, Jim Ryan, was elected state's attorney. He brought structure. There were policies. There was a mission statement. We had some oversight on the decisions that are made by prosecutors. And if there's anything, the biggest complaint, I think, or one of the biggest complaints about overzealousness and overcriminalization is the lack of restraint on prosecutors, both at the local level and at the federal level. I witnessed it firsthand, and I don't know what Steve's take is on it, but I think we did a pretty good job, Phil, in the state's attorney's office. We did a pretty good job in our structure, policies, making sure that equality, which should be the touchstone of sentencing policy, that there was equality, that there was a consistency in the law, that you were treated the same whether or not you were represented by a high-profile private attorney or you're represented by the public defender, that there'd be consistency, that you take into consideration the same factors that you do in any other case. And I think that's from my standpoint, that is one of the biggest problems and remains one of the biggest problems in the system as a whole, that there's no consistency from county to county, from jurisdiction to jurisdiction, from state to state. Back in the 90s, we indicted a guy in DuPage County for a home invasion, sexual assault of a 16-year-old child, held a mother and father hostage at gunpoint. Steve, you probably remember these facts. I'm not going to name the case. But that 16-year-old girl is now a prosecutor in Florida. I'm very proud of her. She's an assistant United States attorney in Florida. Her experience through that prosecution made her want to become a prosecutor. That same offender, one of the same offenders, there are actually 3 offenders, was arrested for the same identical offense after he committed this offense. These people were not immediately captured. Arrested in Minnesota. Suspended sentence and probation for the same offense, except for the rape, home invasion at gunpoint against senior citizens, and discharged on probation. So you have that from state to state. There's really nothing that can be done about it because prosecutors at the local level have really the utmost control. They're confined only by what the General Assembly or the legislature in their states put on the books for them to prosecute. So I'm going to give you, that's just a little perspective in general. Some examples of what things that are going on right now. My first encounter with what I characterize as overcriminalization, regulatory offenses at the federal level was actually when I was in law school. I was still a law student. I was working for a law firm here in Chicago called Epton, Mullen, Siegel, and Druth, and I was assigned to the PBB contamination in Michigan. How many of you remember the PBB contamination in Michigan? No one remembers it. It was the PBB. Bill, you remember it. It was the largest chemical disaster in the history of the world. PBB was mixed, polybrominated bipheenols were mixed in with food for animals at a plant in Michigan that was owned by Michigan Farm Bureau, owned and operated by and Northwest Industries was then the owner, but a case that involved what I characterize as overcriminalization was United States versus Vesicol Chemical Corporation, which subsequently purchased the company originally responsible, and ultimately criminal charges were brought against the company after the civil cases were settled and after the prosecutors watched what was going on. They brought the indictment against the company for a cover-up of the spill, which occurred during the course of early in the 1970s. Ultimately, the case was dismissed by the district court for prosecutorial vindictiveness. The government sat back and watched as the civil cases went forward, and then the government resisted a plea of nolo contendere that was recommended by the district court judge, and only after the plea was entered did they bring the felony indictments. The case was dismissed for prosecutorial vindictiveness. That's a very rare occurrence, both at the state and federal level, but that does happen. In order to bring a charge of vindictive prosecution, though, the defense has tremendous burdens or tremendous hurdles to jump over. Just a little bit about what's going on I wanted to talk about some of the things that are going on here in Illinois. As Isaac said, I did serve on the CLEAR. I thought the CLEAR Commission, the experience was wonderful. We met every few months. Sometimes we'd meet in committee every week or so. We communicated by email. We did memorandums on any issue that required discussion, in-depth, serious memorandum about criminal laws. And the goal was not to try to take away or try to divest the General Assembly of any of their policymaking function, but to make the criminal code easier to understand, eliminate some of the problematic areas, overlapping laws, unlawful or unconstitutional mandatory presumptions. We got rid of those, and cleaned up some of the archaic laws that hadn't been used in many, many years, and we recommended that they be repealed. The work was very rewarding. It lasted 5 years. Former Governor Thompson and former Justice Gino DeVito from the 1st District Appellate Court were our co-chairs, and it was a wonderful experience. I said early on, and we got along very well, the members of the committee, the judges, the appellate court judges, the Attorney General and her staff, my office, former State's Attorney Dick Devine, and then Anita Alvarez. Everyone got along very well, but we all agreed that where the rubber meets the road is sentencing policy. That's where we're going to have our real discussions. So as a result of CLEAR, SPAC was recommended, and SPAC, which is the Sentencing Policy Advisory Council, is now underway, and they have I think their final report is due in 4 years. 4 years or so, and recommendations to the General Assembly. Steve and I were just talking about one of the recommendations that the governor, I expect, has signed, or has he signed that yet? But that bill eliminates felony charges for recidivist prostitutes. You know, right now, if first offense is a Class A misdemeanor, subsequent offenses can be a Class 4 felony if the prosecutor chooses to pursue those charges. That was eliminated by, and as I said to Isaac, I can't comment on whether or not I think that's a good idea, bad idea. I can see both, as I do as a judge, I can see both sides. Try to see both sides. But that is going on. You know, to be an effective prosecutors, you know, SPAC and CLEAR are examples of really what you can do as a prosecutor. You can be reactive or you can be proactive in your community. You can just react to crime and bring charges where you think they're warranted, or you can be proactive in developing, developing relationships between your office, the chief judge, the other judges in your jurisdiction, law enforcement, the public defender's office, and a private bar, probation staff, the Department of Corrections, members of the General Assembly. And I had the luxury of being elected to office in DuPage County, where it gave me a platform which really I took what Jim Ryan had done, and I continued that, where I felt that there was an issue in our jurisdiction that could be addressed by either increasing punishments or coming up with a proposal for a diversionary program. I would do that. You know, I'm very proud of what we did in DuPage County. We formed the first mental health court in Illinois, only the second in the nation. We were the first county to create a seniors and persons with disabilities unit. We also were one of the first with a drug court, and those models have worked well. So that is ongoing work. The Illinois Supreme Court, other things that are going on. has appointed a committee on mental health. It's headed up by my colleague on the 2nd District Appellate Court, Justice Zinoff. Last year, they opened a model facility in Rockford to study and work with the courts and with local jurisdictions, with law enforcement, with the private bar on alternatives for people suffering from mental disabilities or mental illness who end up getting caught up in the justice system, which becomes a revolving door. And adding years to their sentences doesn't really resolve the problem unless you get to the root cause of the problem. At any given day, you can go to the Cook County Jail, go to DuPage County Jail, go anywhere. You'll find, if you did a survey, how many of your inmate population reported upon admission that they had used alcohol or drugs within the past 24 hours, you'd be astonished. It's about 60+%. And about the same percentage of them at some point in time, whether it's before they arrive there or after or while they're in the system, will be diagnosed with some form of mental illness. That is a known fact. That is not something that we are going to address, and I say we, the General Assembly, is going to resolve by simply adding new crimes or new punishments. By the same token, I have been guilty of adding a few penalties, a few new crimes, because I felt that they were appropriate. Rick Feenster's over there laughing and smiling. I put the burden on Rick when I was the state's attorney. But I thought that we tried to be creative. Where I saw something that happened in the appellate court, which, now it never happens, but it did back then. I saw a ruling that made no sense. We'd go to Springfield and change the law. We wrote the grooming law, the grooming statute, where somebody sits behind a computer and plans to molest a child. I think that should be punished as a felony, and now it is. Even though you don't take immediate steps to act on that instinct, if we find you doing it, you can be prosecuted for grooming. That was a result of what I thought was an aberration from the appellate court. A guy solicited a child on the internet, went to a McDonald's, loaded for bear, had condoms, had lubricant, to have sex with the child. It turned out to be an undercover police officer. Notwithstanding that, I felt that that was a substantial step toward the commission of criminal sexual assault with a child. That case was reversed outright by the 2nd District, and as a result of that, we wrote the grooming statute. As a prosecutor, when I was first elected, I made a commitment that we would use the tools available to go after street gangs in DuPage County. We were the first county to sue a street gang using the civil penalties that are available under the Omnibus Street Gang Crime Prevention Act. Rick was also part of that, still handling some of those cases. I also happen to like the title of the charge, which was Birkett versus Satan Disciples. I always like to be against the devil. We were successful. So those are just a few examples of what you could characterize as overcriminalization. I also wrote a law that punishes deadbeat parents who don't pay their child support obligations, created a felony sanction for that. Hasn't worked out so well. It's not used very often, but still on the books. Some could argue that that's going too far because we already have contempt powers if someone's been found in contempt of court for failing to pay child support. So I will grant that that was maybe a little overstep. Anyway, I wrote a lot of laws. We tried to utilize what we had at the local level, though, and I think that's what I try to encourage. If I ever speak, last year I gave a presentation to the Illinois State's Attorneys Association on the exercise of discretion by prosecutors. You have discretion in the courtroom, you've got discretion in the community, with your county boards, with your chiefs of police, with the public defender, with everybody. The prosecutor, despite the attacks on prosecutors that have gone on these last 20 years or so, the prosecutor is still looked upon for answers to these questions that are in our communities and now on a larger stage, the federal government regulatory crime, which, again, as I mentioned, I experienced when I was a young law clerk working in a law firm here in Chicago. The focus should be on equality. Punishments for each offense today are recorded, and judges are required to treat each offender in the same manner. But as I said, there remains disparity from one jurisdiction to the other. That is something that the SPAC group is working on. One of the biggest problems that plagues our system is the lack of information. I know my colleagues, whether you're a private attorney, public defender, one of the problems that plagues our system is the lack of timely information. What's in the pre-sentence report in Cook County, Steve, you know what I'm talking about, you don't get it unless you issue a subpoena or you're lucky enough to have a friend in Cook County to get the full background on somebody. And it's especially important in juvenile, the juvenile justice system. One of the things that I committed to do when I became state's attorney was to reform the juvenile justice system, not just in DuPage County, but throughout the state. I was very proud of what we did in partnership with the Cook County State's Attorney's Office in writing the Juvenile Justice Reform Act of 1998. We made it tougher in some sense because we adopted a balanced and restorative justice model for our state. Instead of placing the best interest of the child paramount in all cases, the rights of crime victims and the community were on equal footing, which is a sense of what justice really is. Justice is supposed to be a balancing of the interests of the community, the victim, and the defendant and his or her family, the people who are impacted by the crime. So that's what we tried to do with the balanced and restorative justice model that we implemented in 1998. Something we did in DuPage. Again, you could argue it's overcriminalization, it's going too far. I instituted juvenile screening, felony screening for juvenile offenders. In other words, if a juvenile committed a felony offense, he was not going to be sent home to mom and dad without a phone call to the state's attorney's office to determine whether or not we would be filing a petition to get that offender into court within a short period of time. When I took over, we were chronically delayed. Juvenile cases would be sitting for 3 months, as long as 6 months, before a charging decision would be made. And you can guess what occurs during that period of time. The youthful offender is back in the same community that led him or her down the path towards criminalization in the first place. A broken home, single-parent families, no structure at school, truancy, drugs, gangs, etc. So we changed that. Now, within 3 days, you have a decision, and that offender or potential offender is in court answering, and you don't see kids sitting out there having 3, 4, 5 arrests before their first court appearance, which is what we used to see. And I think from my standpoint, that's really where our focus, if we want to get a handle on crime, in particular in our state, in this county, is focusing on juvenile justice. And I know there's been a tremendous amount of effort on it. There's always new ideas. But one thing that we cannot give up on is the youth. And, you see, read what's going on with appointments of, what is it called, a special master to take over and look at what's going on with juvenile justice in this county and throughout the state. That has to be something that is one of the key focuses. Comments about prosecutors over the years, just a couple of the comments that are made. As I mentioned, when I was the state's attorney, we did experience a lot of remarks from the media, in a negative vein. Probably all of you recall that the death penalty debates that we had. We don't have the death penalty in Illinois any longer, but part of the debate was overzealousness by prosecutors and ignoring evidence and putting blinders on, not seeing the forest for the trees. And there was some merit to those arguments. In fact, there was a lot of merit to some of those arguments. From our standpoint, I think prosecutors were given a short shrift by the media and by members of the General Assembly, because the reality is that many of the reforms, most of the reforms that were enacted, were written by prosecutors. I wrote the post-conviction DNA testing legislation. That came out of my office. And I don't have any original ideas. I steal them from somebody else. But when my name was on the door, it was my office, so I take credit for them. I also wrote the law that gives the defendant the right to access to anything with regard to forensic testing, post-conviction, the right to, we codified the right to raise a freestanding claim of innocence, regardless of time, limitations that are otherwise in the post-conviction statute. We wrote the law expanding the DNA database to include all convicted felons. Those tools have been an effective one-two punch, not only against criminals in solving cold cases. Something you read in the paper, a case that was solved from 30 years ago, 20 years ago, based upon a DNA hit, as well as the exoneration of people who have been wrongfully convicted. Those were prosecutors' ideas. When you hear about overzealous prosecutors, remember those good things that were done by prosecutors. And one of the criticisms that I think also has a great deal of merit, and I can say it because I didn't cross my mind until long into my career as a prosecutor. One of the current flaws in the evolving power of the prosecutor is the failure to force him or her to face the cost of prosecutorial decisions. In most jurisdictions, county prosecutors use local funds to operate their offices, and therefore prosecutors must be concerned about the cost of prosecution. But because prisons are operated with state funds, affecting a split funding of the criminal justice system, most prosecutors need not directly consider the availability of prison space or prison resources when making charging and bargaining decisions. That's true. That is true. Prosecutors don't think, again, I'm not speaking about all prosecutors, but many of my former colleagues don't consider the cost to society. What's the difference if it's 4 years or 8 years? It's a big difference in costs. Not saying that I'm a proponent of lower sentencing necessarily, but it is a consideration, and I think that's a legitimate concern for the public, and that's why it's important to have a group like SPAC studying these issues, to come up with recommendations. Do recidivism studies. I encourage recidivism studies. When I was first elected, I mentioned this earlier about juvenile justice reform, our county was outsourcing kids. We're sending them to farms in Colorado, Pennsylvania, to get them fresh air and, a new way of life and still moral fiber in them. And we were spending millions of dollars. Phil, you were in juvenile back then, weren't you? I can't remember. Do you remember? Yeah, you were. I thought it was your idea too, Phil. No, sir. In any event, what I did when I was elected, I said I want to take a look at 200 cases, similar cases that we handled here in DuPage County with local services, and 200 cases out of state, 5 years out, and see what the rate of recidivism is. It was about the same. So we stopped spending the millions of dollars. We began bringing resources locally, whether they be private resources. The Boy Scouts of America was a big partner. Churches were partners, and obviously the probation department, public defender's office were all important partners. Back in the 90s also, the DuPage County Board approved in 1993 the building of a huge new juvenile justice center with 90 beds, because the projections were that based upon what was going on in the 80s and 90s, we're going to need 90 beds 10 years out. Last year, DuPage County closed their youth home because they only average about 20 kids a night, and they sent their kids to Kane County. So we did something right. We got this model right. And I think that's what we should all try to do, is look at our models. Take a look at how sentencing, how it's working, and then make change. And the way to make change is having groups like this making proposals for policy changes in Springfield. I've had the privilege of having a great career as a prosecutor, learning how to try cases, but then also as a manager. I became a manager about 26 years ago, 1986, or 1985 was my first managerial position, and I got to have input in policy decisions, training local law enforcement, going to Springfield, arguing legislation, the debate, and that is the one thing I miss. One of the things I miss my colleagues, but I also miss the public debate, the opportunity to sit down with my colleagues, make a proposal. We had offenders that were being put out on bond who were high-risk offenders. Nothing was being done when somebody would reoffend. We had a case named a person named Ann Jones who shot her husband while he was sleeping. She had already been charged with attempted first-degree murder for committing the exact same crime a few months earlier. As a result of that case and others like it, particularly domestic violence and gang cases, we initiated what we called the State's Attorney Target Offender Program, electronic monitoring while people are on bail. Why wait until they're sentenced if they are a high risk to reoffend? The State's Attorney Target Offender Program gave those offenders the ability to be in their community, with their family, working, earning a living, keeping their job, and at the same time protecting the crime victim. We were also the first county in Illinois to use SCRAM, secure remote alcohol monitors. For people who are discharged who have an alcohol problem, the SCRAM monitor allows them to be in the community, but if they drink, it's going to trigger the monitor, they're going to be rearrested, brought back in. So that's what I tried to do as, when I was state's attorney, and I stole a lot of great ideas. Wrote the vehicle forfeiture law for DUIs and DWLRs. That's an area where people might think that's overzealous. We've forfeited over 4,000 vehicles, I think, in DuPage County using that legislation. The rate of recidivism is almost nil. It's almost nil because you can say to your wife, honey, I got arrested again, I need $100 for bond. Tell her, honey, I got arrested and they took the car. That's a tough pill to swallow. So, you know, I had great success, and as a prosecutor, I hope that my career as a justice on the Illinois Appellate Court will be nearly as fulfilling as my job as state's attorney. It was a great experience. I had the benefit of working with great people on both sides of the aisle, politically, on both sides of the aisle as a prosecutor, working with my friends and colleagues in the defense bar, with great judges who I learned so much from and am continuing to learn every single day. It's been a great career, and I think my time is up, and Hage did a good job giving me the post. So that's it. I'd be happy to answer any questions, unless you want to get rolling. Okay, I can take a couple of questions. Okay. Oh, go ahead.
No, thank you for coming, and thank you for your speech. It was very informative. I think you're right that sort of both prosecution and sentencing do play a role in sort of serving as a sort of deterrent value for crime. But and you spent a lot of your talk focusing on sort of crimes against sort of like rape, murder, child abuse. I mean, things that sort of everyone can sort of say, yes, those are morally wrong. But when it comes to sort of more economic crimes, like saying, okay, we're going to send you back to jail because you're just sort of the one that's a few that pop in my head is it's illegal in Chicago to sell flowers without a license, or it's illegal to, I think in the state of Illinois, or maybe just Chicago, to
use plastic bags now.
I was going to say, like work as a barber if you've previously been a felon, and a number of all these other economic crimes. I was just wondering, just curious, like what your opinion is on how to best calibrate the sort of both prosecutorial and sentencing. Let me go back a little bit, just to say, I mean, the choice itself to sort of prosecute those who are trying to make a living is it in itself sort of a political decision to say, hey, like what you're doing is wrong, for X reasons. I mean, and that's maybe a decision for the legislature, and they've decided that, but. Again, sort of, and for the prosecutors as they're approaching the decision to prosecute these individuals and for selling flowers or engaging in these economic decisions, how do you calibrate the incentives there?
Well, first of all, you have a good question. The one thing on economic crime, I also on the same theme, overcriminalization. I wrote the law and helped craft and get through the General Assembly, increasing punishments for serious financial crimes. I could not see the notion I'm sending a guy to prison for stealing his third carton of cigarettes, a couple of misdemeanor retail thefts and rows of felony, and here's an offender who steals hundreds of thousands of dollars, he's getting probation. Something's wrong with that picture. So we increase penalties. But what you're talking about is the local, what happens at the local level. I mentioned regulation. I mean, businesses now, you have to have regulation management. You have to have somebody who makes sure you're in compliance with labor laws, local laws, state laws, county laws, municipal laws. It's a moneymaker. And again, Bill, I'm being very cautious about what I'm saying here. I'm not giving any opinions, but from my perspective as a prosecutor, I always believed in the Latin phrase, de minimis non curat lex. The law does not deal in trivials. I tried as a prosecutor to live up to that and not deal with trivial nonsense. At the local level, with home rule, cities and villages can adopt a variety of laws. We had a case in DuPage County. Someone was sentenced to $14,000 for a fence violation because every day was another charge. By the time the case got to trial, and the judge is like, "What am I supposed to do? It's mandatory. I don't write the laws. It's mandatory fine." So there are, there are abuses. There are abuses in every system. But again, I always tried to live up to that adage: the law does not deal in trivials. And we shouldn't be. As local prosecutors should not be. But at the same time, I always told my attorneys, we don't handle widgets here. Every case deserves your utmost attention. And that's what prosecutors should do. But at the same time, there are occasions where you just say, that is nonsense. We're not prosecuting that. That's what prosecutorial discretion is all about, is making the decision as the gatekeeper, what comes in? How am I going to spend the resources of my office? If you have a community that's plagued by gang graffiti, you might have a crackdown for a period of time against the people who are committing the graffiti. But if that measure doesn't work, then you have to look for some other solutions. So that's a very long answer to a relatively short question.
It seems to me that a lot of what you're trying to get at, and what some of the other people around here might be getting at, are violations of municipal ordinances that don't even get into the
No, the state's attorney. Well, they get to the court. They can. A lot of them are handled by fine only, or you'll have an administrative hearing, and then if you choose to, you can have a court hearing. But most of them, people just don't want to take the day off. They don't want to come back to court. They'd rather pay the fine than miss a day of work.
Yes, but that's where a lot of the abuse is.
Again, I don't offer commentary like that anymore.
Excuse me. I may be one of the only persons in this room, beg your pardon, who can remember the dates of the mid to late 70s when determinate versus indeterminate sentencing was one of the issues in legislative races throughout Illinois, whether a particular candidate favored determinate, i.e., if you do this crime, you do 20 years, or indeterminate sentencing, which was if you did the crime, you did 5 to 18 or whatever. The question I have is whether the switch to determinate sentencing has eliminated the prospect of parole, not only as a salutary effect on the conduct of people within the joint. In other words, if they have the prospect of parole, they behave better, but also as a way, as was proved for generations in the federal system, of equalizing sentencing among the 102 counties. Obviously, in the federal system, there's not counties but districts. But equalizing sentencing among the 102 counties throughout the state, where different judges, because of whatever hometown affinities they might have, decide to sentence somebody for less than somebody else might get for the similar crime committed somewhere else.
Well, has it had an effect? I think in some areas it has. It has reduced recidivism in some areas with respect to some crimes. And determinate sentencing took really the authority away and a lot of discretion away from judges. So judges had to pick between a fixed number as opposed to an indeterminate sentence, 20 to 60, for example. Now it's a fixed number. Yeah, and the truth in sentencing laws came about, 16, 18 years after that. I'll tell you a quick story about this issue. when Jim Ryan was the state's attorney and looked like he was going to be the attorney general, George Ryan, who was running for governor, came up with this 1520 life. You'll remember that, part of the Safe Neighborhoods Initiative. And I was asked by Jim Ryan, I was chief of criminal, take a look at this. What do you think? I thought I had problems, single subject problems, also problems with the Illinois constitutionality, proportionate penalties clause in the Illinois Constitution. I see Steve nodding his head. You saw the same problems I did, Steve. So I gave an opinion in a letter that I thought the statute was unconstitutional. I get a call from the Secretary of State, George Ryan, and he said, "What's this nonsense? You don't like this bill?" I said, "Well, Mr. Secretary, with all due respect, I think it has problems. I'm not saying it's going to fail. I think it has problems. It could be addressed. We could do a better job." And he said, "Well, why are you worried about that? Let the Supreme Court worry about that after the election." That's one of the problems. We don't look at long term. Like you mentioned, the determinate sentencing. I think with some offenders it has paid huge dividends. Hardcore criminals, child sex offenders who are among the most recidivist type of offenders, we're being put back into the community even after they had been sentenced to the penitentiary because of the indeterminate sentencing. I know I prosecuted a lot of those people during the course of my career. So I felt at that time, and again, I'm echoing what I thought as a prosecutor, I thought they could be and were very effective. At the same time, it gave us a lot more power. It gave prosecutors a lot more power. I think that overall, determinate sentencing has added substantially to the inmate population, not just in the state of Illinois, but across the country. And that's what SPAC should be looking at, and that's what SPAC is looking at. Long-term study about recidivism and rates of recidivism.
Yeah, I spend more time in the federal system, and the problem, pardon me? Depends. And the thing I've noticed, and I'm certainly not alone in this, thank you, is that with the sentencing guidelines in the federal system, prosecutors have an incentive to just load up on whatever they can figure out, whatever they can even make up in many cases, to add on. RICO claims are being abused, and a lot of these, these crimes that really should be, if they're proved guilty, should be 2-year crimes. They're now loading it on, so you're potentially facing 30 or 40 years, and you're really forced into taking a plea a lot of times. And that, to me, is the biggest problem with determinative sentences or sentencing guidelines. I just wonder what your opinion is.
Well, I don't give opinions anymore.
Or what's your
I can tell
feeling
you
on
this,
these statutes is.
what I did as a prosecutor, you can use leverage, but ultimately, and this is in some of the, I didn't use my prepared remarks tonight, but I give a presentation. Last year I gave one to the Illinois States Attorneys Association. The year before that to the National District Attorneys Association about controlling discretion. The charges that you bring should be the charges you're going to seek. You don't, and this is the NDAA standards, the ABA standards. Leveraging is permissible. Plea bargaining, when it's properly done, is a wonderful tool, and it should be. Prosecutors have to be much more careful now in the state system when they're bargaining. I wrote an opinion, People versus McRae. The state charged a guy with murder using a gun. At the sentencing hearing, they reduced the charge by eliminating the gun from the charge, but their factual basis included that he shot the victim. That's a mandatory 25-year add-on. The minimum is 25. I was the author. I reversed the case. The void sentence voids the plea. So you have to be very, very careful. And you know this as a federal defender program. Your job is to get the best possible disposition for your client. And prosecutors are entitled, and Bordenkircher versus Hage, the case law says this. Not only do they have the authority to leverage, they should leverage. Because what would happen if we didn't leverage? Not we anymore. They didn't leverage. The system could never handle. They could never handle. I mean, speedy trial problems. There's an opinion coming out that I wrote recently about speedy trial concerns. Prosecutors are under the gun. They've got to get your case to trial, or you get a plea, because they have got to move on to the next case. You know that in America, there's no question about this whole concept of overcriminalization. It's a problem that should be addressed at the federal level. I didn't give you the update. There is a congressional committee on it. You can get it on the website. There's a list of things. You can look at what's going on. But it's being studied at the federal level. What should prosecutors be focusing on? These cases that are regulatory welfare type prosecutions, or should they be focusing on racketeer influence corrupt organizations? Should they be focusing on gang violence, gang activity, gun trafficking, really serious issues? You know, the Obama administration gets praised on the one hand and criticized on the other. You can't do it. You're not going to be perfect. They've been criticized for their aggressive stance on deporting illegal immigrants when they commit low-level felonies. That forced their hand. They then issued a memorandum that went out to all the U.S. attorneys that you don't have to be so harsh. You have discretion. You can pull back a little bit. So there's a lot that goes on. But as a judge, I see it. You know, as a prosecutor, I saw it. I saw abuses. I saw too lenient treatment sometimes, and I saw overzealousness. You know, in the criminal code, there is a provision that says the Illinois Supreme Court should take all steps to ensure that there's equality in sentencing. Unfortunately, that hasn't occurred. But we're headed in the right direction, I think, with SPAC. Okay? Thank you so much for having me tonight. Thank you. Thank you.
I think it is clear how fortunate we are to believe in the power of ideas.
Supply the common sense and the fresh thinking of the Manhattan Institute.